Hi, everyone. Welcome to the first episode on recent developments that will be put on by the Big Tech and Monopolization Committee of the Antitrust section of the New York State Bar Association. My name is Kai Rozga, and I'm here in my capacity as vice chair of the committee, and not my employer. I just want to make that clear. And with me is Shaoul Sussman from the FTC. He's an associate director for litigation at the Bureau of Competition. He's here to help us understand better some of the recent notifications and proposed changes to two aspects of the U.S. Merger review regime. The first one being the HSR form, the pre-notification filing, and the second being the substantive merger guidelines, which set out how the agencies approach reviewing mergers. I'm going to briefly introduce the topic here by just noting that, although the changes in these procedural and substantive changes are largely industry agnostic, we will actually, for purpose of this discussion and our membership, focus on how these changes would impact technology deals in particular. Without any further delay, Shaoul, can you set the stage for us and sort of tell us what is it that these changes are trying to accomplish, and focusing in particular on any tech-specific concerns that the agencies have that might be motivating these changes?
Sure. So first of all, Kai, thank you for inviting me. It's great to be here. I'll start with the usual kind of disclosure that the views that I'm going to share today are my own, don't reflect the views of the Bureau of Competition at the FTC or any of the commissioners. But yeah, just generally speaking about these two initiatives, they really, I think, dovetail and kind of build upon each other in a sense. So on the front end, when it comes to the type of information that we're seeking to receive from parties that are proposing transactions, this has been kind of an area where I think, at least on the staff level at the commission, just for many years, there's been a realization that the information that we're receiving right now is sort of insufficient or lacking when it comes to screening for potentially, problematic deals, deals that may lessen competition. But really, the initiative of the guidelines, as well as recent legislation in Congress, really drove a lot of the substantive changes in this proposal. So that's on that aspect. And like you mentioned, when it comes to tech, the proposed rulemaking when it comes to notification in the HSR really talks to a research or study that was done during Chair Simon's regime as chair during the Trump administration around serial or kind of acquisition in the tech space by dominant firms, and that really informed a lot of what we're doing when it comes to the HSR form. And the guidelines as well kind of have, I think, incorporate a lot of lessons that were learned in the last 10, 15 years, especially around tech. So we have a guideline now that speaks, and we're going to talk about platform dynamics, but also speaks to kind of big cases that both agencies brought in recent years, right? If we think about the complaint that the DOJ filed in the Google ad case, or the complaint that the commission filed in the Meta case, right? Those two challenges really focus on mergers, and kind of we really wanted to make sure that we're learning from the lessons of the last decade, and that's reflected in the guidelines as well.
Thank you for that overview. Why don't we start with the HSR filing, the pre-merger notification form? Tell us a little bit about how you see those proposed changes impacting the disclosure for technology parties that are doing technology deals.
Right. So when we think about the disclosure surrounding technology deals, I think it's very important to think about it. I think in terms of a small tech company getting acquired versus, very large tech acquisitions. So I would think in terms of the small acquisitions, right, there's going to be a lot more in terms of broadening the horizon beyond the question of whether there's an overlap between the target and the firm that is acquiring this smaller tech company would really want to get more information about why that acquisition takes place. For bigger tech acquisitions, there's probably going to be significantly more information that will be provided because of this expansion beyond overlap, or even very trivial things, which is, information in the past, right, that focused maybe primarily on NICE codes, right? There's only one NICE code to describe the entire tech industry. So we're going to have more granularity, and hopefully we'll be able to earlier in the process really sift between non-problematic deals that don't need any additional review and more problematic transactions because of this additional information we're going to get.
Yeah, thank you. And the nature of the information that will be sought now, are there ways in which it tackles different competitive theories that maybe weren't captured in the previous form, or perhaps weren't front of mind for those of us representing or working for clients that are in front of the agency with filings?
Yeah, so I think the form really calls onto or kind of corresponds with the guidelines. And in the guidelines, right, we're also expanding, right? We have a very solid base that's based on the 2010 guidelines when it comes to horizontal transactions. To a certain extent, maybe to a lesser extent, also on the 2020 vertical guidelines. But then there's also what I would describe as more an expanding of the universe of the theories of harm. And we really wanted to make sure that in the form really corresponds to that expanding universe. So if we have theories, that talk about serial acquisitions, we wanted to make sure that we get more information in the form around past acquisitions. If there's theories of entrenchment, right, that we might discuss in a bit, we really wanted to get beyond the mere overlap description and think about what more holistically about what is the relationship between those two firms, what are the synergies that they're bringing. And we added, the more narrative kind of questions into the form to really tease out the dynamics that might be more complex than, just overlaps.
Understood. And is there an aspect of the new proposed form that would capture what we call non-reportable deals, or information about non-reportable deals that might be of particular importance in the technology sector, given the agency's findings in that area recently?
Yeah. So as I mentioned, there was a report that was published in, I think, 2021, but really was done primarily during the Trump administration, looking into the acquisition strategies of big tech firms and kind of doing a real retrospective in that area. And one of the things that was highlighted by that report is the number of non-reportable transactions, or transactions below the reportable threshold of the HSR that didn't receive scrutiny. So one adjustment that was already made kind of in the way we investigate tech deals and deals generally is now in the process of the second request, we would typically ask more questions around past acquisitions. But in the new form proposal, the rule proposes receiving that information up front from the firms that are reporting around their past acquisitions. And really, this can tell us two stories. One is really around serial acquisitions and getting a broader picture of acquisitions, for example, in a given overlap. But it could also give us a better story of the intent or the interest of the firm to enter a certain market, right? So it could also have some information around potential competition, for example. But there could also be, maybe most of those transactions were benign, and we just wanted to get that information up front to get a better understanding of that.
Yeah, understood. And your mention of potential competition makes me think of one other area where I think technology companies in particular will probably be interested in talking about with respect to the form, the HSR form, which is pipeline products or forthcoming services or products that might be in the pipeline. For example, a target that might have some potential plans, or even the acquirer. Can you explain how that's going to have a more significant sort of be emphasized more in the new proposed HSR form?
Right. So again, I think we're ready. When we start doing investigations, we typically ask for this information, right? We ask kind of what are the products in the pipeline, and what are your kind of plans for the next 2-3 years, when it comes to R&D and product development. I mean, it comes up in tech acquisitions for sure. It also comes up in the pharma space. But here again, the idea is to have that information provided in the initial screening through the merger form, and really to hopefully kind of, once we get that information up front, to ease the burden, both for kind of agency staff that are reviewing transactions, but also teasing out kind of the questions that we're might going to ask, in advance, so we know earlier in the process whether it's a problematic or non-problematic transaction that might need additional review.
Great, thank you. Well, why don't we move on to the second topic, which is really the substantive analysis that the agency engages in once it receives a form and has a filing on its desk. Can you highlight a couple of what you might consider key changes being proposed in the revised merger guidelines that could impact technology deals?
Right. So as I mentioned, we're really thinking a bit more expansively when it comes to theories of competitive harm. So we have what I would say is more the bread and butter, horizontal overlap questions, right? Whether these two companies are competitors in the same space, and whether the transaction is going to eliminate competition in that overlap. One of the guidelines that is really, I think, more front and center in this version is really this question of head-to-head competition, right? So very interested in, were these companies fiercely competing with each other before kind of the acquisition took place? But we're also thinking about non-horizontal relationships, right? We're thinking about distribution or supply relationships. So non-horizontal, some call, or, in certain circumstances, vertical relationships. But we're also looking beyond the vertical relationships or the horizontal relationships to understand better the dynamics or the motivations that drive a transaction, and really to understand kind of the synergies. So, many transactions that don't have horizontal overlaps, or kind of very clear vertical relations, and also have very benign synergies, are obviously not problematic and kind of not going to be of a lot of interest for us. But what we're looking at is basically, are there unique synergies, or are there unique kind of traits that might lead to a lessening of competition, even if those firms are not vertically or horizontally kind of situated on the geometry. So an example of this would be the entrenchment theory of harm that we're going to discuss a bit later, but it could also be potential competition, etc.
Yeah, well, actually, that's a great prompt to talk about the guideline 7, I believe it is, that talks about entrenchment or extension of a dominant position. That one in particular flags, I think, some specific examples that make me think of technology deals like switching costs and network effects and nascent competitive threats. Can you talk for a couple minutes about how that guideline might be, something that people doing tech deals should follow?
Yeah. So, the entrenchment theory of harm goes back quite a few decades, and really, though, was affirmed by the Supreme Court, hasn't been, litigated or actively pursued as a theory of harm for many, many years. But, you know, that being said, it really uh, has a lot of elements that, like you said, really correspond to tech markets, right? Because the thing we're thinking about is really a firm that is dominant in a certain market, or is dominant outside that market, acquiring the B side, and thereby either entrenching its own market position or entrenching the target's market position within a given market. So it is a theory that hasn't been, litigated for many years in the merger context, but an example that illustrates this dynamics, this type of dynamic, would be the Microsoft case, which is a more recent case. That was a case that involved Section 2 and not an acquisition. But if we could imagine that Netscape was a target of an acquisition by Microsoft, the theory of harm is that through the acquisition of Netscape, Microsoft, for example, would cement itself or in a dominant position in the operating system market, despite the fact that Netscape wasn't itself an operating system. And the court really didn't go into a lot of detail about whether it was vertically situated or horizontally situated vis-a-vis Microsoft's market. So the idea here is also to be a bit more flexible when it comes to articulating the relationship between the two markets, and really think about the harm or the potential entrenchment of dominance within the markets of either the A side or the B side.
That's an interesting thought experiment, to use, the sort of single conduct firm case, the theory there as a marker for how to think about potential M&A activity. Is that also helpful perhaps in discussing another aspect of the proposed guidelines, which tackles specifically with multi-sided platforms?
Yeah. So we have 8 guidelines in the proposed, the draft guidelines, that are kind of what I would say theories of harm, or the general theories that incorporate both economics and law, and think about how a transaction may substantially lessen competition. But then guidelines 9 through 12 really articulate specific scenarios in which the guidelines might play out and how the agencies will go about applying them. So one of the areas where we wanted to really make sure we're focused on is the platform context, really, because there's such an explosion in the digital economy in the last 13 years, right? Since the 2010 guidelines came out, we really thought that this idea of a platform really deserves its own kind of section that articulates how we would think about these dynamics. And in that section, we really break it down into specific theories of harm that might be applicable in the platform context. So you might have what we might call like the old school overlap, or head-to-head platform versus platform dynamic.
Mm-hmm.
There might be a merger that will lessen competition on the platform. So it's not really about displacing the platform or cementing the dominance of the platform, but it might lessen competition between an app that's operating on a platform and a rival app that's also operating on the platform. And the another theory that is also more platform specific might be around displacing the current dominant platform, right? So, for example, if there's a transaction that lowers barriers to entry, or kind of lowers switching costs between platforms, and the acquisition basically prevents that switching or raises the barriers, those are kind of like the type of dynamics that we're going to be very interested in looking at. And again, without going into specifics, we could really look at, cases that are currently litigated in the Section 2 context, or, the Section 5 context, whatever you want to call it, and, the Facebook complaint or the DOJ complaint versus Google and Facebook, and really see there that a lot of these platform dynamics are now teased out in the Section 2 context. And the idea here is hopefully for us to intervene earlier in the process and to prevent those dynamics from playing out.
Yeah. Yeah, thank you. I mean, my personal sort of wrap up or commentary here is just, there are some major procedural and substantive changes being proposed. They will lead to more disclosure, or at least front load the disclosure of certain information to the filing stage, as opposed to perhaps a voluntary access letter or a second request. And it sounds like the agency, or we should expect the agency, to be looking at broader theories of competitive effects or harm, perhaps ones that we've seen in monopolization context, perhaps not. But that, the technology sector in particular is going to be thinking creatively, I think, about, how to approach and how to anticipate these changes going forward. So thank you for that overview. I really appreciate it. In the last couple of minutes here, I thought we could turn to process. These are both at the proposal stage, without getting into the nitty and gritty of what the process is. Can you give our membership maybe a little bit of a sense of what sorts of things do you think the FTC is looking to hear from stakeholders or other interested parties in the technology sector surrounding these proposed changes?
Yeah, so that's a really great question. And I would start with the guidelines. And I would say when we initiated the guideline revision process last year, we opened the docket and we asked for folks to really comment and provide us with their kind of view around kind of whether we need to revise the guidelines, how should we revise the guidelines. And really the response from the public was overwhelming. We received more than 5,000 comments. And and when we looked at comments that are text specific, we saw kind of various comments, right? We saw comments that said, if there's going to be too much scrutiny of tech deals, especially of nascent companies, that might disincentivize investment and kind of entrepreneurship. And then we receive comments that also describe the opposite dynamic, where companies and founders kind of talked about how their ability to grow without risk of potentially like an acquisition of their rival, or an acquisition happening in general, really would allow these companies to arrive at a more mature kind of process and kind of grow internally. And it was very interesting to see those types of comments. And I think now that the agency's kind of laid out what they think should be the framework reviewing tech transactions, we're very much interested in getting the feedback and getting kind of comments, right? Whether it would be about the platform section or, potential competition, entrenchment, even horizontal context. And we hope that comment process will really improve the guidelines. When it comes to the rule, the HSR rule, there we're really going to focus on responding to the comments we receive. We really want to understand kind of the scope of the burden, the scope of information that's currently available to parties, how we should tweak it, how should we think about certain prongs. So we're very much looking for that feedback and looking forward for engagement from the tech sector.
Great. Well, I mean, it sounds like there's a lot of room for folks to chime in, share their thoughts, and speak now. Shaoul, thank you so much for joining us. It's been a real pleasure. And thank you everyone for watching. We'll stay tuned for more.
Thank you so much.